The federal court in Nevada has issued their decision in favor of the small bull administration. However, there are still two yet undecided lawsuits, one in Florida, one in Arkansas, regarding the alleged failures of the SBA to properly comply with the CARES Act, specifically the Economic Injury Disaster Loan Program. Now, how will these cases affect your ability to get the full $10,000 grant and the EIDL loan up to $2 million? Will the SBA be called to task for their abysmal performance? Hello and welcome to Stephen Carlson Show. I'm Stephen Carlson. I'm a tech entrepreneur, real estate investor, author, YouTuber, and volunteer paramedic. One thing I am not is a lawyer, so don't sue me if anything in this video is wrong, okay? Remember, I'm just some dude on the internet, and you should most definitely seek legal counsel from a competent lawyer. All that aside. Now, once again, I wish to thank all of you guys for watching, liking, and subscribing. My channel has exploded in popularity recently and has nearly doubled each of the previous 2 weeks, and I'm on par to do the same this week. This would not be possible without you guys clicking like, commenting, and subscribing. I'm very humbled by all your support, and I really appreciate it. Thanks. All right, now let's get back over the EIDL update news. As I covered in my video on Monday, July 6th, multiple members of Congress are less than pleased with how the SBA, under Administrator Jovita Carranza, has chosen to implement several, let's say, unilateral rules that are in stark contrast to the intentions of the CARES Act. To make things even worse, there are many secret rules that are applied internally within the SBA without telling any of the applicants, leaving business owners in the dark. They just don't know what the rules are. A few of these unilateral rules is how the SBA has implemented their own reduction of the $10,000 grant to $1,000 per employee up to $10,000, forcing many small businesses to accept a puny $2,000 or $3,000 when they were budgeting and hoping for the full $10,000. Various members of Congress have penned letters to the SBA, and they all pretty much say the same thing, like, "Why are you making up your own rules? Why are you not following our intent of the law?" Of course, I'm paraphrasing with a little creative license here, but pretty much that kind of sums up what they've been saying. And simply put, Congress is pissed at the SBA. Ranking member of the Senate Committee on Small Business and Entrepreneurship, Senator Ben Cardin, was very clear in his intentions on the EIDL program when he and his team drafted it. Here's a quick clip from Wednesday, March 25th. That was 2 days before Congress passed the CARES Act, and here is how they intended the $10,000 grant to work.
We now allow you to make that application, and with that application, if you need to get cash immediately, the SBA can write you a check for up to $10,000. And we want that done within 3 days. We want that money out in days, not weeks. We hear that all the time from small businesses. We need help now.
Now, because I am not a lawyer, let's bring in a great YouTuber and attorney for his opinion.
So with all these facts, it's pretty clear that Congress actually intended for the CARES Act to provide for a $10,000 advance if an applicant asked for it, and that the SBA didn't have the authority or discretion to limit that $10,000 and had to provide it within 3 days. But here's the problem. This is something that I alluded to in my last video. The only time that a court will look outside of the four corners of the statutory language is if that language is unclear. If the court decides that the language in the CARES Act is clear and that it clearly allows the SBA to have discretion with regard to the amount of the grant and with regard to how long it takes them to get the grant to people who applied, then the court does not have to look at anything else, including the letters from Congress or any other legislative history. And this is a rule of construction that has nothing to do with the CARES Act or any of the lawsuits that we're talking about. This is a standing rule that has been used by courts for hundreds of years in the United States.
Now moving on to a specific case in Lit Ventures LLC versus Carranza, a suit filed in Nevada alleging, in part, that the SBA failed to provide the $10,000 within 3 days. U.S. District Judge Jennifer Dorsey stated in her order, the defendant reaches this conclusion after quoting a few choice phrases from the CARES Act and recounting page upon page of public statements that lawmakers and the SBA have made in the wake of the Act's passage. But statutory interpretation, as the Supreme Court always says, begins with the text and, where the statute's language is plain, courts do not consider the legislative history or any other extrinsic material. And here, my analysis begins and ends with the relevant statutory text. So in non-legalese, basically the judge is saying that judges should use extreme caution if they are to use the speeches or letters written by politicians when the judge interprets the law. To the extent that a judge does bring these matters in, they must limit them in scope only to the parts of the law that are not clearly defined. And for this reason, the judge will limit her decision to what is actually written in the law, not what Congress may or may not have intended when they drafted this law. Or, stated another way, it is not the responsibility of the courts to correct a poorly written law. If Congress has a different intention than what was written, it is the obligation of Congress to go and correct it, not the courts. She further states that the CARES Act tells an applicant what it may do when applying for an EIDL in response to COVID-19. Ask the SBA to provide an advance within 3 days of receiving the EIDL application. Now, this is the exact analysis that I made months ago in my video when I said the 3-day stipulation only means that the applicant may request a grant within 3 days, not that the SBA will necessarily pay it within the 3 days. I think the overall confusion with the entire EIDL program is Congress is saying one thing and the law says another. Now that Judge Dorsey has weighed in, we have some general idea as to how the other lawsuits will go. Now, there's one thing that I did notice, and I think this is a golden nugget that will be very helpful to some of you. The defendant, Ventures, contends that the SBA has determined that it will only fund emergency grants when an applicant is approved for a loan. Now, what is interesting is Judge Dorsey's order says the SBA offers evidence to show that this is not how it processes emergency grants. Now, this is in stark contrast to what many of you guys have been saying in the comments. Now, my interpretation of this is the SBA, under penalty of perjury, has told the judge that they do not deny grants to businesses that are denied the loan. If you are in this boat, I think you have this great quote that you can use in your appeal. Now, I want to make this very clear. There is a very important distinction here. This only appears to apply if you were denied the loan. They will still give you the grant. However, if you are approved for the loan, but you choose to refuse to take the loan, it's possible the SBA may refuse to give you the grant or advance. So what does all this mean? Honestly, I think unless Congress addresses this in the next stimulus act, the SBA is basically free to make up their own rules as they go along, as long as they're within the rough framework laid out in the law. The courts do not appear to be interested in rewording a poorly written law, and honestly, I agree with the judge in her ruling. The job of a judge is to interpret the law, not rewrite it. I am still a firm believer that the advance/grant really should have been completely separate from the loan. Businesses should have been able to apply for either or both, depending on their needs. Small business owners nationwide are desperately trying to pay their rent, payroll, and other expenses. And there really is only one fix for this, and the EIDL program is not it. Now, I'm going to go out on a limb here, and I can already see some of the nasty comments people will write. I am not coming from partisan left versus right, just a business owner that wants the best for my businesses and that of millions of other Americans. We need to reopen America now. Initially, the plan was 15 days to slow the spread. That was 115 days ago today. Now, I understand and agree the country was facing a pandemic that, without swift action, would have cost the lives of millions of Americans. After 2 weeks, we should have regrouped and looked at the numbers. The country really needed another 2 weeks, so about a month total. Then we should have reopened the country immediately. Yes, people will get sick, and sadly some will die. There's nothing we can do to stop that. My business partner had it. He was very ill for 3 weeks, and he said it was the worst feeling of his life. Now, luckily for him and for all of us, he's very physically fit and was able to recover. His college-age daughter also contracted it, and basically they all shared it around the office. Thankfully, nobody else has become ill, and they are all now better. Now, I'm sure some of you are yelling at your screens right now.
He's just a rich guy. All he cares about is money. Unlike, unsubscribe.
Yes, well, I am financially comfortable. I make a very good living at what I do. However, how many millionaires do you know that also volunteer as a paramedic? For almost 10 years, I was in the top 3 call takers at my volunteer rescue squad agency, regularly taking 200 to 300 emergency calls per year. I don't say that to toot my own horn, just say that I do really care about people. Now let's just put me aside for the moment, because there's something very important I want to get across. With proper social distancing and precautions, reopening the economy 80 or 90 days ago, we would have seen the same spike of infections that we currently see today. All we really did was just kind of kick the can down the road 100 days. But the damage from this shutdown has caused countless small businesses across the nation to fail in ways that they probably will never be able to recover. Now, it doesn't really matter if we would have opened in May or June or, heaven forbid, kept the lockdowns until next year. The infection spikes basically would have been the same. Now, a big shout out to Vitaly and his excellent channel. As I've stated here multiple times, while I have studied law in college, I am not an attorney. And as an actual attorney, Vitaly can provide unique insight and a breakdown of these lawsuits on his channel. Why don't you guys check out his channel? The link is in the description below. Tell him that the Stephen Carlson Show sent you. What other channels do you guys watch and love? Who should I feature here next? Why don't you comment down below and let me know. Thank you very much for watching. Please make sure you click like, subscribe, and comment down below. Doing so really helps with the YouTube algorithm, and it's something I very much appreciate. Thank you, and I'll see you next week.